Good morning, this is your Kelso Report for Monday, August 27th, and I'm your host, Clark Kelso. Now, as I think we all recall, the immigration laws provide that aliens who have previously been convicted of certain crimes are subject to an order of removal. One such crime is possession of methamphetamine. Well, an issue that commonly arises in immigration proceedings is how to determine whether aliens who pled guilty to certain state charges have actually been convicted of one of the specified crimes under federal law. A good example is last week's decision in Cabantic v. Holder, where, according to the state court abstract of judgment, the petitioner had pled guilty to possession of a controlled substance. The problem is, not all controlled substances under state law trigger the removability provisions of the immigration laws. So the question becomes whether any other evidence established what controlled substance is the basis for the state conviction. And there are strict rules limiting what the federal courts can look at. In this case, the abstract indicated that the petitioner had pled guilty to count 1 of the complaint. And count 1 expressly charged petitioner with possession of methamphetamine. The Ninth Circuit held that where the abstract of judgment or minute order specifies that a defendant pled guilty to a particular count of the criminal complaint or indictment, the immigration judge can consider the facts alleged in that count. Applying this rule to the facts before it, the court concluded that the abstract of judgment and the complaint taken together did establish that the petitioner pled guilty to possession of methamphetamine and was therefore removable under the immigration laws. Next, we have an interesting attorney fee case from the Ninth Circuit. The petitioner in Costa v. Commissioner of Social Security sought attorney fees under the Equal Access to Justice Act after successfully appealing the Social Security Administration's denial of his application for disability benefits. The magistrate judge granted the fee request in part, but determined that the 60 hours the petitioner's attorneys spent working on the case were excessive. Applying what amounted to an informal rule limiting fee awards in routine Social Security cases, the magistrate judge reduced the number of hours to 41. Well, the Ninth Circuit held that it was improper for the district court to apply a de facto cap on the number of hours for which attorneys may be compensated on the Equal Access to Justice Act in a routine case. Instead, individualized consideration must be given to each case to determine whether the hours charged were reasonable in the circumstances. A good result for attorneys under the Equal Access to Justice Act. Next, we have a remedies decision from the Supreme Court of California, an important one and a broad ruling. The decision was occurred in Lung versus Verdugo Hills Hospital, where the California Supreme Court unanimously abandoned the common law release rule. The facts were as follows. 6 days after his birth, the plaintiff suffered irreversible brain damage. Through his mother as guardian ad litem, he sued his pediatrician in the hospital in which he was born. Before trial, plaintiff and the pediatrician agreed to a settlement of $1 million, the limit of the pediatrician's malpractice insurance policy. At a jury trial, plaintiff was awarded both economic and non-economic damages. The jury found that the pediatrician was 55% at fault, the hospital 45% at fault, and the parents 5% at fault. Total amount of damages was about $15 million. On the hospital's appeal, a major contention was that under the common law release rule, plaintiff's settlement with the pediatrician also released the non-settling hospital from liability for plaintiff's economic damages. The Court of Appeal reluctantly agreed, correctly recognizing that under the common law rule, the release of one joint tortfeasor released all joint tortfeasors as a matter of law. The California Supreme Court granted review to consider the continuing viability of the release rule, and it decided unanimously to abandon the rule. The problem with the rule is that it assumes, contrary to fact in many cases, that when a plaintiff settles with one defendant in exchange for a release, it has received full compensation for its injuries. But there can be many reasons for settling with a defendant for less than full compensation, including, as in this case, the fact that the defendant has a cap on insurance. To avoid the problem of undercompensating plaintiffs who settle with releases, the Supreme Court abandoned the old release rule. Now, settlement with joint tortfeasors will reduce economic damages by the amount of the settlement, but will not entirely bar recovery against another joint tortfeasor. An important ruling. Finally, we have a case from the Court of Appeal, California Court of Appeal, dealing with covenants not to compete. Now, as I think you may know, as a general matter, California law is pretty hostile to covenants not to compete contained in employment contracts. Generally, such covenants are unenforceable in most cases, and there are only a handful of situations, mostly involving entertainment contracts, where such covenants may be enforced. At the same time, however, there is an exception to the general rule for covenants that are entered into as part of the sale of a business, so that the purchaser of the business can protect its goodwill. In Phil Point v. Moss, the defendant sold his stock in Crave Entertainment Group to Handelman Company, and the stock purchase agreement contained a 3-year covenant not to compete. Now, in this case, the defendant actually stayed on as an employee of Crave, and so he signed, in addition, an employment agreement containing a 1-year covenant not to compete after termination of employment. After 3 years at Crave, the defendant resigned, and then 6 months later, the defendant began working for a competitor. Handelman's successor sued the defendant for breaching the covenant not to compete, and also sued the defendant's new employer for interference with the contract. The defendants made a motion for non-suit, which the trial court granted. The 4th District affirmed. The defendant had satisfied the 3-year covenant not to compete that was part of the stock purchase agreement. No breach there. And the court concluded that the 1-year additional non-compete clause was unconscionable and unenforceable under California's general rule. The plaintiff argued that the additional 1-year covenant not to compete should be viewed as part of the sale of the business, but the court rejected that argument, finding that the 1-year covenant was in fact a separate provision that was part of the defendant's employment relationship, and it did not fit within any exception to California's general rule forbidding such covenants in contracts of employment. And that's it for today's Kelso Report. Have a great day in the law.